Alright, so let us continue with our discussion. We are still in Rule 126. We are done with the instances where a valid search warrant is issued and how is it implemented. But I think I ended the makeup class last time with a question. Is it possible for the state or for government authorities to seize, to search, to conduct search and to seize items even without warrant? Okay? And the answer is yes. Right? Okay, for a while class ha. Sige. So, yes, it is possible. In the case of Epi Jr. versus Ulat Maredo, GR number 148117, March 22, 2007, penned by Justice Sandoval Gutierrez, the following are the exceptions where search and seizure may be conducted without a search warrant. Number one, you have search incident to a lawful arrest. Number two, search of a moving motor vehicle. Third, search in violation of customs laws. Fourth, seizure of the evidence in plain view. Fifth, search when the accused himself waives his right against unreasonable searches and seizures. This gives you the idea that it is waivable. That right is waivable. Six, stop and frisk. And seven, exigent and emergency circumstances. The only requirement in these exceptions is the presence of probable cause. But this probable cause here is different from the probable cause that we learned previously. In warrantless searches, probable cause must only be based on reasonable ground of suspicion or a crime has the rule or fixed formula in determining probable cause for its determination varies according to the facts of each case. And that is why under this part of our discussion, there is a need to inspect cases because it's a case-to-case basis. Okay? So, in this case, nangyari dito was the search involved is a moving vehicle. So, where will it fall? It may fall under exception number 2, di ba? Search of a moving motor vehicle. Okay? The the police authorities flagged down the vehicle, but because it did not stop, the police were forced to chase it until it reached a particular place in Shilan, La Trinidad. A search of the vehicle disclosed several pieces of Benguet pine lumber, and petitioner could not produce the requirement or the required DNR permit to cut and transport the same. So, was the search valid? The Supreme Court said yes. Diba? Remember, it's one of the exceptions where a search may be conducted without a search warrant. So where a vehicle sped away after noticing a checkpoint and even after having been flagged down by police officers in an apparent attempt to dissuade the police from proceeding with their inspection, there exists a probable cause to justify a reasonable belief on the part of the law enforcers that the persons on board the said vehicle were officers of the law or that the vehicle contained objects which were instruments of some offense. Okay? So, yan. Let us go to the exceptions again. So, first, you have the search incident to a lawful arrest. This is also found in Rule 126, Section 13. A person that is lawfully arrested may be searched for a dangerous weapon or for anything which may have been used or constitute proof in the commission of an offense without a search warrant. You have to remember here that the codal is very, very careful in saying that the arrest must be lawful in the first place because this is incident. The search is incident to the lawful arrest. So if the arrest is not lawful, then in effect, the search is also not valid. Okay? In the case of Uy K. Teng versus Villarreal, there was a search warrant issued to search a building somewhere in Chinatown, Binondo, Manila, on the ground that there was opium or other drugs in that house. The owner had no choice because there was a search warrant. The owner had no choice but to allow the search. And when the search was conducted, they did not find the opium. Okay? Instead, what they found were firearms, unlicensed firearms. And because they discovered the presence of these firearms, should even if hindi siya nakadescribe sa warrant of arrest, should the police authorities get the firearms? The answer here is they did here is they arrested. They arrested the accused for illegal possession of firearms and they seized all these firearms. The Supreme Court said here, okay, because there was an issue whether or not what they did was a valid conduct. The Supreme Court said that the seizure of the firearms is not illegal, even if hindi siya yung nasa search warrant talaga. Okay? Why? It is still valid because it is in the course of their search for the opium. They discovered another crime, which is illegal possession of firearms. And since they discovered the commission of another crime, they have the authority. So since they discovered the commission of another crime, that is what you call an in flagrante delicto. Okay? In flagrante delicto situation, caught in the act. So the crime is illegal possession of firearms. And since they discovered that, the commission, they have the authority to arrest the owner even without a warrant. That is a valid arrest. Now, because it's a valid arrest, can they also seize the item even without a search warrant? The Supreme Court said yes. Okay? Since there is a valid warrantless arrest, automatically there is also a valid warrantless seizure. Okay? Uy Kiteng versus Villarreal is the case. Now, we also have the case of People versus Catan, 205 SCRA 235. The Supreme Court here said that when you say search of the person, it includes the immediate premises because for all we know, wala siyang baril sa kanyang person, pero yung baril niya nandoon sa kanyang drawer, which is immediate sa kanya. Okay? At gamitin pa sa iyo during the conduct. So it includes the surrounding premises. That is still covered. Okay? Now, in the case of People versus Gerente, here there is a witness who testified that at 7 o'clock in the morning, she saw 3 persons started drinking liquor and smoking marijuana. And the witness overheard them killing Clarito. Narinig lang niya. Okay? 9 hours later, or at 4 p.m., the police received the report of the molding incident. So a police investigator went to the hospital where the victim was brought and was told that the victim died on arrival. Police investigator and his companions proceeded to the scene of the molding. And there, they were informed by the said witness, yung nakarinig, that she saw the killing and pointed to Gabriel Gerente as one of the 3 men who killed Clarito. So what the police did was they went to the house of Gerente, who was then sleeping, and asked the latter to come out. And when he did, he was arrested, even if wala pang warrant of arrest. And in the course of the arrest, he was frisked. The police finding in his pocket a coin purse containing dried leaves wrapped in a foil. So question, is the arrest there valid? Was there a commission of the offense? There was none because remember that he was already sleeping. Okay? However, the Supreme Court said here that the arrest is still valid pursuant to the hot pursuit rule. So warrantless arrest was valid. Okay? Remember that dito, dahil walang caught in the act, the policemen already obtained personal knowledge of the commission of the offense because of the investigation. And because the arrest is valid, the seizure of the marijuana in his coin purse was also valid because it was made incidental to a valid arrest. So the rule here on the first exception is that you have to see to it that the arrest is lawful, either with a warrant or without a warrant, basta dapat valid ang arrest because that will have an effect as to the validity of the seizure conducted incident thereto. Okay? Now, so ano yung second nating exception? Search of a moving motor vehicle. But let's skip that first. We have already, in fact, anyway, we have already discussed Epi Jr. versus Ulat Maredo, di ba? As an example. Let's go to another example of or another instance of a warrantless search, a valid warrantless search. Ito yung stop and freeze rule. The stop and freeze rule is otherwise known as a Terry search. Huwag mo akong materi-teri. If you remember that. So, it's stop and freeze rule is otherwise known as the Terry search. So, here, the guidelines that the authorities must observe or must consider are the following: the appearance of the person, the time, and the occasion of the search. Let's inspect the cases. Posadas versus Court of Appeals, 180-83. Here, about 10 o'clock in the morning, two policemen were conducting surveillance. And during the surveillance, they spotted Posadas carrying a booty bag. They noticed him to be acting suspiciously. Both policemen approached Posadas and identified themselves. But when they introduced themselves, Posadas attempted to flee. So they caught him. A check of the booty bag yielded 1 caliber .38 Smith & Wesson revolver, 2 tear gas grenades, and live ammunition of .32 caliber gun. Posadas was not able to show the necessary license or authority to possess the firearms and the ammunition. So he was arrested and the items were seized. The question now is that, was there a valid search and seizure? Okay? It could be, we could argue that pwedeng mahulog siya doon sa seizure or search incident to a lawful arrest because naamanjoy crime na nakumit. However, in this case, paano mo malaman na there was a crime in the first place na wala mang overt act, di ba? So, ang palusot ngayon ng authority is the stop and freeze rule because yun nga, nagkaroon ng suspicion sa behavior ni Posadas, and when as he attempted to flee. So there was already a probable cause on the part of the authorities to hold him. And because of that, yung items na na-recover are also validly seized. At the time the peace officers identified themselves and apprehended Posadas, he attempted to flee. They did not know what he had committed or was actually committing illegal possession of firearms. So meaning to say, hindi siya mahulog sa in flagrante delicto, hindi rin siya mahulog sa hot pursuit kasi wala nga silang alam kung ano yung commission. Okay? It's just that suspicious yung act ni Posadas, and when he was asked, he attempted to flee. So with all the more reason na nabuo yung suspicion ng mga authorities. They did not know that. They just went there and introduced themselves. They just suspected that he was hiding something in the booty bag and they did not know the contents. So when he was stopped and freeze, doon na nakita. The search in the case at bar is reasonable considering that it was effected on the basis of probable cause. There was probable cause when Posadas was concealing something illegal in the bag. Okay? Now, another case, People versus Mengote. Mengonte was arrested by the policeman here because he was acting suspiciously. He was looking from side to side while holding his abdomen. When searched, he was found with .38 revolver with 6 live bullets. The incident occurred before noontime. Hindi siya tumakbo compared doon sa Posadas case na tumakbo. Dito wala. Okay? Nilapitan siya, nakapkapan ng baril, and then, yun na. He was convicted of illegal possession of firearms. He was convicted. Mingote contends that the weapon was not admissible evidence because it was illegally seized and therefore a fruit of the poisonous tree. So tama ba ang argument ni Mingonte? The answer is yes. Evidence is inadmissible. When Mingonte was arrested, he was not committing any offense. Okay, so what is the lesson here? The lesson in this case is that if you successfully prove that the seizure that was conducted was illegal or unconstitutional or invalid, then whatever was taken from you, even if hindi na yan siya masauli sa'yo, whatever was taken from you is considered as a fruit of the poisonous tree. And because it is considered as a fruit of the poisonous tree, you cannot use that as an evidence. That is the rule in Article 3, Section 3. Okay? So whatever is taken pursuant to an invalid seizure cannot be used as an evidence, even if the items that were seized are illegal in the first place. Okay? Now, we have also the case of People versus Evaristo, December 11, 1992. Okay? So, somebody fired a pistol. There were two policemen who started chasing him. They found two people in the corner and they started asking these two people. Now, one of the policemen saw that the guy's side is bulging. When they searched him, they found the gun or a gun. So he was arrested. So somebody fired a pistol, ha? You check the facts. Somebody fired a pistol. And then hindi talaga nakita kung sino yung nag-fire ng pistol. So nagtakbuhan, may hinabol rin yung police, pero definitely yung police hindi rin sure kung yung hinabol ba nila ay yung tao na yun. Until they found out two people in the corner and they started asking these two people. Isa sa dalawang tao na ito, or isa sa mga policemen, so na yung isa sa dalawa, yung side niya is nagburot or bulging. And when they searched him, they found a gun. So, yun na, nag-conclude na sila agad na siya yung tao na nag-open fire. So, here, the Supreme Court said that when the police officers chased after somebody who fired a pistol and came upon Evaristo, the visual observation that his side is bulging along with the earlier report of gunfire as well as the police officer's professional instincts are more than sufficient to pass the test of the rules. Consequently, under the facts, the firearms taken from Evaristo can be said to have been seized to a lawful and valid arrest. Okay? So here, the seizure was valid. Okay? And the arrest is also valid. In the case of Malacat versus Court of Appeals, December 12, 1997, the Supreme Court distinguished the stop and freeze rule or the Terry Doctrine from that of a search incidental to a lawful arrest. Sabi ng Supreme Court, the stop and freeze rule here, while probable cause is not required to conduct this, it nevertheless holds that mere suspicion or a hunch will not validate a stop and freeze. A genuine reason must exist in light of the police officer's experience and surrounding conditions to warrant the belief that the person detained has weapons concealed upon him. While the search incidental to a lawful arrest, the arrest must be valid. The validity of arrest determines the validity of the search because the search here is just incidental to the arrest. Okay, the law requires that there first be a lawful arrest before a search can be made. The process cannot be reversed. Again, the process cannot be reversed. In the case, or let's go to the next example. So far, we have already discussed two exceptions. Search incidental to a lawful arrest or incident to a lawful arrest. Second is the stop and freeze doctrine or the Terry Doctrine. Now, let's go to the search of moving vehicles like that of the case sa Epi Jr. versus Ulat Maredo. Okay? Another case that may fall under that example is the case of People versus Mamstead, 198 Scrap 401. Here, NARCOM agents receive a tip that a bus will pass from Mountain Province, and that there is a Caucasian inside. So they approach him and ask him, "What is your name? Can we see your passport?" The Caucasian refused. Then during the inspection, the NARCOM agents opened his bag and found hashish. The same was found in the teddy bear. So he was charged with illegal possession of prohibited drugs. Was the search conducted valid? The Supreme Court said yes. Warrantless search was valid. The receipt of the information and the suspicious failure of the accused to produce his passport, taken together as a whole, led NARCOM to reasonably believe that he was trying to hide something illegal from the authorities. In the case of People versus Aminuddin, 163 Scrap 402, okay, here, NARCOM agents pa rin, they receive a report that a vessel coming from Mindanao has Mr. Aminuddin carrying with him a marijuana. So the agents waited at the port for the vessel to arrive, and they saw a man that fits the description. They freeze him, and when the maleta was opened, it contained prohibited drugs. Subsequently, the man was arrested. Was the search, let's focus on the search. Was the search valid? The Supreme Court said there was no valid search warrant. Okay? There was no valid search even. Because if ganito yung nangyari, ang sabi ng court, there was enough time for NARCOM to secure a search warrant. There are still 2 days before the vessel will arrive. How come that you did not obtain or apply for a search warrant? So here, because this is vessel okay? So what is the difference here? People versus Mamstead and People versus Aminuddin. Sa Aminuddin na case, vessel kasi ito, and it will take time for the vessel to transport from one place to another. So pag may checkpoint at land trip ka, madaling makatakas compared sa vessel. That is why there is no need for you to obtain search warrant kapag land trip. Pero pag vessel yan siya, kasi hindi yan siya madaling makarating. Okay? So, there is no need, or there is a need for you to obtain a search warrant. Okay? People versus Exala, 221 Scra 494. With respect to the checkpoints, as a rule, visual search is required. The exception is when there is probable cause which justifies a reasonable belief that either a motorist or the content of the vehicle is an instrument in the commission of an offense. The presumption stands that they are regularly performing their duties. Please take note of that, please. Okay? So, checkpoints, hindi, ang rule lang talaga ng checkpoint sa kaso na to, as the case is saying, is that plain view lang dapat. A visual search. Hindi kailangan maghalugog. In fact, hindi nga kailangan na i-open mo yung, yung windshield. Okay? But because we are in Davao City and we abide with the order or the mandate of the government, the request of the government. So, that is why we do. Okay? But that is not, that is not compelled actually. We are just being asked to cooperate. Okay? So, tayo naman sa part natin, alam natin na malaking ginagawa. We do it. Para bilit naman to guys. But paghalughog ng sasakyan, pagpapababa sa private vehicle is too much. Okay? Unless na lang if there is probable cause that will justify that. Okay? That there is a reasonable belief that either a motorist or the content of the vehicle is an instrument in the commission of the offense. Okay? Remember that there is a presumption that the police authorities are regularly performing their duties. Now, another of thing Um, warrantless search na valid is evidence in plain view. So we have the case here of People versus Musa, where the Supreme Court said that plain view doctrine is usually applied where a police officer is not searching for evidence against the accused, but nonetheless inadvertently comes across an incriminating object. It must be immediately apparent to the police that the items that they observe may be evidence of a crime, contraband, or otherwise subject to seizure. So what are the requirements here? In this instance, People versus Doria may be helpful for you. So, because in that case, the Supreme Court laid down the requirements. First, the law enforcement officer in search of the evidence has a prior justification for an intrusion or is in a position from which he can view a particular area. Second, the discovery of the evidence in plain view is inadvertent, meaning to say, walang ginawa because it's plain view nga eh, plain view. And third, it is immediately apparent. Okay, for a while plus ha. For a while plus ha. Okay. So, second is the discovery of the evidence in plain view must be inadvertent. Wala di ukay, kundi tungod lang nakita lang jud nimo siya inadvertently, you saw the item. And it is immediately apparent to the officer that the item he observes may be evidence of a crime, contraband, or otherwise subject to seizure. Itong exception na to, ang kailangan dito ay mata. Okay? No need of hands, no need of mouth, on the eyes. Kaya ang ating tinatawag siyang plain view. Okay? So, in the case of Rivaldo versus People, GR number 170589, April 16, 2009, penned by Justice Carpio, the police officers went to the house of Rivaldo because of the information relayed by Sunit that petitioner had in his possession illegally cut lumber. So when the police officers arrived there, the lumber were lying around the vicinity of petitioner's house. The lumber were in plain view. In the Supreme Court said that under the plain view doctrine, objects falling in plain view of an officer who has a right to be in the position to have that view are subject to seizure and may be presented to as evidence. The law enforcement officer must lawfully make an initial intrusion, okay, or properly be in a position from which he can particularly view the area. In the course of such lawful intrusion, he came inadvertently across a piece of evidence incriminating the accused, and the object must be open to eye and hand and its discovery inadvertent. So here, when asked whether he had a necessary permit to possess the lumber, petitioner failed to produce one. And petitioner merely replied that the lumber in his possession was intended for the repair of his house and for his furniture shop. So there was already, okay. So there was therefore probable cause for the police officers to confiscate the lumber. There was therefore no necessity for a search warrant kasi nga immediately sinumbong yun siya. Mere possession of forest products without the proper documents consummates a crime. Okay? So what else? What are the other instances where a search warrant is not needed? Custom searches. When a vessel arrives from abroad or the customs agents aboard the vessel to look for smuggled items, they can conduct warrantless searches for the enforcement of custom laws. Okay? In the case of Hison versus Court of Appeals, the Supreme Court said that search and seizure without search warrant of vessels and aircrafts for violation of customs laws have been the traditional exceptions to the constitutional requirement of a search warrant. It is rooted on the recognition that a vessel and an aircraft, like motor vehicles, can be quickly moved, can be quickly moved out the locality or jurisdiction in which the search warrant must be sought and secured. Yielding to this reality, judicial authorities have not required a search warrant of vessels and aircrafts before their search and seizures can be constitutionally affected or effected. Okay? Now, we also have the so-called consented search. Dito naman, gi-waive mo talaga yung right mo. You have the right, yes, but you consented them to conduct it even if wala silang search warrant. So you consent the search. So People versus Burgos, okay, in this case, the Supreme Court said that here it was not a consented search when a person remains silent, that is not consent. Okay? General rule or in layman's, 'di ba? Ang layman's term or layman's expression, sabi natin, silence means yes. Pero here, applying that principle in the warrantless search, silence does not mean consent. Okay? It must not be construed as yes. Okay? So please take note of that case, People versus Burgos. Veroy versus Layage. The search here was not valid because the permission was to look for rebels and not for firearms. If you are looking for rebels, then you do not search the drawers because rebels cannot fit in the drawer. Okay? There are no rebels inside the drawers, and yet here ginawa nila ang panangidang nag-ukay naman sa drawer. Okay, imposible ng tao na knowing file a motion to quash a search warrant if there is a search warrant or a motion to suppress evidence obtained thereby if there are evidence taken, especially if there is no search warrant. And this may be filed in and acted upon by the court where the action has been instituted. If no criminal action pa ang final, the motion may be filed in and resolved by the court that issued the search warrant. However, if such court failed to resolve the motion and there is a subsequent filing of the case in another branch or in another court, the motion shall be resolved by the latter court that handles the case. All right? So that ends our discussion for Rule 126, particularly warrantless search. Question from the class? Okay, this is still included in the exam, ha? You better familiarize yourselves with search and seizure. Okay, God bless everyone and have a good day.